Hello all, welcome back to Law with Subathra Mylsamy. So imagine waking up in a world where every online action you take is meticulously tracked, analyzed, and monetized. Your personal preferences, purchase history, even the places you visit. Now, this is not a science fiction. This is our digital reality. So as technology evolves, so do the concerns about the data privacy. The question isn't just about who holds your data, but how securely and ethically they can be managed. Now, if you get into the Digital Personal Data Protection Act, India's landmark response to safeguarding individual privacy while also enabling the digital innovation. So, before we break it down, let me remind you on the key players in this framework. Now, the data principle, that is you, the individual whose personal data has been collected. Next is the data fiduciary, the entity that determines why and how your data is going to be processed. Then is the consent manager, an independent body that helps you to manage your data rights. Then is the data protection board, the watchdog that ensures the compliances and enforces penalties. Now let's dive into the core aspects of the act, keeping in mind the draft rules. So first angle is the notice and consent, which is the foundation of your privacy. One of the most critical aspects of the act is the explicit itemized notice and informed consent. This means companies or organizations should provide a clear, specific, and transparent notice before collecting your data. They have to explain why they need your data. They have to give you an easy way to withdraw your consent at any time. A point of debate here is the law does not prescribe a standard template for these notices. While this gives business flexibility, it also creates room for ambiguity. Now, should there be a standard format is a question. Now, coming to protection of the children's data, under this act, parental consent is mandatory for the data which is collected on the minors. Targeted advertising and behavioral tracking of children are completely prohibited. But there is a challenge here. In a world which is dominated with AI driven content recommendations, how enforceable are these restrictions? Next is the security measure. Now, this is a legal mandate and security isn't optional. The Act mandates for encryption, masking, and access controls to prevent breaches. So, continuous monitoring and logging to detect threats is mandatory. A mandatory 1 year retention of the logs is there. Now, the dilemma here is if a user requests data erasure, does that override the 1 year retention rule? The law is silent on this. Next is on the data breach notification. Now, if a data breach occurs, organizations must report it within 72 hours with details on the nature of the impact of the breach, the steps taken to mitigate the damage, and how many individuals were affected. But there is no threshold for reporting a breach. So, could this lead to a notification fatigue where users are bombarded with breach alerts, reducing their effectiveness? Now, the role of the consent managers, it is whether a game changer. Now, to simplify the consent management, the Act introduces consent managers, allowing the users to track their consent history, modify or withdraw their consent easily. But here's the catch. Only entities with a net worth of 2 crore can qualify as consent managers. Now, could this requirement stifle the competition? Next is the data retention and erasure. Companies can only keep personal data until the original purpose is fulfilled. The user can withdraw the consent. Before deletion, the users must also receive 48 hours of notice. But can companies delay the deletion under the guise of verification? The rights of the data principles here, it empowers the users to have certain powerful rights. Right to access, which is request for your copy of a stored data. Right to correction, fix your incorrect data. Right to erasure, which is demand for a deletion. Right to withdraw your consent, which means revoke your permission anytime. So companies must also provide a privacy con on their website to facilitate these rights. Next is the significant data fiduciaries. These are special obligations. If a company possesses large volumes of sensitive data, it qualifies as a significant data fiduciary. This means conducting annual data protection impact assessments, undergoing third party audits, as well as appointing a data protection officer. Now, these are the global best practices, but do they go far enough is the question. Now, coming to the cross border data transfers, it is a moving target. The government can restrict data transfers to certain countries. While this aligns with EU's and GDPR, it introduces regulatory uncertainty for certain multinational business. The question is, should there be a clearer guidelines on trusted countries for data transfers? To conclude, the DPDP Act is a turning point in India's data governance framework. It empowers the individual's demands greater accountability from the businesses and also aligns with global standards. But the challenges remain. Can small businesses keep up with the compliance cost? Will the government's discretionary powers on the data transfers deter foreign investments? Will consent managers truly be independent or add another bureaucratic hurdle? Data protection is more than a legal issue. It is a technological, ethical, and policy driven challenge that requires ongoing dialogue. As we step into a data driven future, one thing is clear: privacy is no longer a privilege, it is a right. I hope this video would have been informative. Thank you so much for watching. See you next time. Bye bye.